this broadcasting is brought to you by the Turkish Arbitration Academy. Our guest today is Professor Laurence Shore. He's a well-established practitioner, scholar, arbitrator, and a very good friend. He is an expert on international commercial law, international investment law, international litigation, and international arbitration. I think everyone dealing with arbitration would have at least read something Larry has written or heard one of his presentations. So he's going to deal with developments in US law in respect of arbitration within last year. Larry, the floor is yours.
Thank you so much, Professor Yeşilırmak, for kind introduction, and thanks to you and to Professor Kafali for inviting me. It's a real honor to be in this series of presentations, and at some point soon, I need to visit Istanbul again and hopefully visit the university. As Professor Yeşilırmak said, I'm going to speak, and I'm told it would be okay if I speak for about 40 or 45 minutes on developments in US arbitration law and practice in 2023 and maybe a little bit in 2024. And I'm very happy after my brief presentation to answer any questions about the content of my presentation or anything else about US arbitration law and practice, and I'll attempt to give answers that are sound. Additionally, because I know in this format it's sometimes difficult to get questions out and time is short, please don't hesitate to email me afterwards. I'm on my law firm's website and email address, BonelliErede in Milan, and I'd be delighted to engage in any exchanges on this topic. So let me start and ask Professor Kafali to put up my first slide, which is on the legislation foundation of arbitration law in the United States. And I apologize in advance for those who are well familiar with the National Arbitration Act in my home jurisdiction, which is known as the Federal Arbitration Act of 1925. But I think it's important to just briefly discuss the foundation of arbitration law in the United States, because so many of the court opinions are an effort to come to grips with the provisions of, as you can see right off the bat, an arbitration act that next year will be 100 years old. And of course, it's extraordinary in a fairly vibrant international arbitration jurisdiction like the United States that the National Arbitration Act is so ancient. And in fact, if you look at there are 4 chapters to the Federal Arbitration Act of 1925. And if you look at the critical first chapter, Chapter 1, General Provisions, there are 16 sections to the general provisions, and sections 1 through 14 have remained unamended from 1925, the date of enactment of US arbitration legislation. And it's extraordinary because, as you know, so many national arbitration acts, whether it's the UNCITRAL model law adapted by more than 60 countries, or the English Arbitration Act, or the French Civil Code, which includes their arbitration legislation, they've all had very modern makeovers. But in the United States, and part of the difficulty of getting one's head around US arbitration law, it's this ancient Arbitration Act, which is I think the source of the problem, some of the interpretive problems. The Federal Arbitration Act comes into being as an exercise of the Constitutional Commerce Clause, the Interstate Commerce Clause in the United States Constitution. So the reason why the Federal Arbitration Act applies to arbitrations involving foreign parties is because that under the exercise of the Commerce Clause, the Congress determined that foreign or interstate commerce among the states of the United States will be covered by this federal act. And so the general provisions have much to do with maritime, which would have been a very important source, as I think we all appreciate, of international arbitration, even in the very early period of the 1920s. And it deals with the relationship between arbitration and the courts. You won't find in sections 1 through 14 many of the things that you would find in modern arbitration acts, like the UNCITRAL model law. And so the courts have to interpret very old provisions and have to, in a way, fill the gaps when those provisions don't address modern issues. Now, there were 2 sections added to the Federal Arbitration Act in 1988. One is very interesting, but not to be discussed further today. That is that the act of state doctrine would not affect the enforcement of arbitration agreements or arbitration awards, and that's included so as not to conflict with the New York Convention. And then there's a section on appeals, section 16, also added in 1988, which is significant in 2023 in Supreme Court cases, which I'll come to in a moment. Chapter 2 is the New York Convention, and the United States became a signatory in 1970. Chapter 3, the Panama Convention, the United States became a signatory in 1990. And then there's an interesting chapter that was added in 2022. And this was part of, as everyone may recall, the United States, the Me Too sexual harassment campaign that has been, I think, very important in US domestic politics and international politics as well. And the final case that I'm going to discuss today will touch on this. There can be no pre-dispute arbitration agreements relating to sexual harassment or sexual assault disputes. That is to say, parties cannot agree under this new chapter of the Federal Arbitration Act in a contract that disputes about sexual harassment will go to arbitration. You cannot have an arbitration about that as a matter of a pre-dispute arbitration clause in a contract. So that's the Federal Arbitration Act foundation. And there's one very important thing to keep in mind about it. The United States Federal Arbitration Act is meant to be interpreted to encourage and favor arbitration. And so a lot of the legislation that, a lot of the court cases that have interpreted the Federal Arbitration Act are trying to fill in the gaps to support international commercial arbitration. And in particular, as part of this support, and this relates to the cases I'm going to come to that were decided by the Supreme Court and the Federal Circuit Courts of Appeal in 2023. It is, in particular, an important support for the enforcement of arbitral awards. So for arbitrations seated in the United States, an award coming out of that arbitration, if you want to overturn it, you really have to hit the mark. That is to say, a strong presumption in virtually every instance that a challenger to an award seeking a vacatur or annulment of that award at the seat of arbitration in the United States, it is a very high barrier to overcome. Under the Federal Arbitration Act, applying the Federal Arbitration Act, U.S. courts in particular favor the enforcement of arbitral awards. And that's a key thing to keep in mind about U.S. arbitration. Even though the U.S. is such a litigious jurisdiction, and there are massive numbers of cases in the courts, arbitration itself is favored, international arbitration under the Federal Arbitration Act, and the awards coming out from such arbitrations, you really have to meet a high bar in order to get the award annulled or vacated. Now, let me say one final thing about this slide. I've been talking about the Federal Arbitration Act. However, there are state arbitration acts. Every state in the United States has an internal domestic arbitration act. So if the arbitration doesn't concern commerce among the several states or commerce among foreign nations, that is to say, a party coming from outside the United States bringing an arbitration claim against a party in the United States, if it doesn't concern that, if you're in the state of Oklahoma and you have two Oklahoma parties and the subject matter of the arbitration is a contract that is to be performed within Oklahoma, having nothing to do outside Oklahoma, the Federal Arbitration Act might not apply, and there might be a state arbitration act. However, you usually, but not always, need not worry about the State Arbitration Act if you have an international arbitration seated in the United States, because the Federal Arbitration Act preempts any state act or any state law that is perceived to be an obstacle to Congress's purposes in enacting the Federal Arbitration Act. And as I just mentioned before, one of Congress's purposes in enacting the Federal Arbitration Act was to encourage and favor arbitration, and especially arbitration awards. So you usually don't need to worry about a state arbitration act if you're litigating, if you're arbitrating, that is, in the United States. But you might have to be concerned if the Federal Arbitration Act does not cover an issue and the State Arbitration Act or a state law is not deemed to be contrary to the purpose of the Federal Arbitration Act. So that's the foundation. I'm sorry I've taken so long about it. Professor Kafali said take a couple of minutes. I've taken more than a couple of minutes, but I think it'll help explain these court cases. So Ömer, if you go to, thank you, the next slide. So there are two leading United States Supreme Court cases that I wanted to bring to your attention in 2023. And the first of these cases is all about the relationship between the federal courts and also the state courts and arbitration. And you'll see in this case why arbitration is favored. And here it is, Coinbase versus Bielski. And the holding here relates to two parties, okay, one of them brings a case in court against the other, and there's arguably an arbitration clause that the other party is able to refer to. So the other party brings a motion to compel arbitration. All right. Now, the motion to compel arbitration is denied. So what happens? Under Coinbase, what happens is that the district court in which the litigation has been brought, its proceedings are automatically stayed during the pendency of an appeal of the court's denial of a motion to compel arbitration. And you can see here, this is a 5-4 decision of the US Supreme Court, and it reverses a decision made by the United States Court of Appeals for the Ninth Circuit, which covers above all California. A lot of California arbitration cases go to the US Supreme Court, and as you see here, many of them get reversed by the Supreme Court. Now, why does this case matter to arbitration practitioners? So you think you've got an arbitration clause, and the claim has wrongly been brought in federal court instead of arbitration. You bring your motion to compel arbitration, you lose, but you appeal, and you're entitled to appeal under Section 16 of the Federal Arbitration Act. The question is, what happens to the court case during your appeal? And what happens is it can't go on while your appeal is being heard. And why does that help you if you're an arbitration practitioner and your party wanted arbitration? Because without the stay, litigation would proceed while the denial of the referral to arbitration is under appeal. So you get your appeal, but without the stay, you'd have to continue litigating. And as we all know, what does that mean in the US courts? Well, that means heavy discovery. So the importance of this case is, while your appeal is being heard and you're still trying to get into arbitration, the other side can't make you go forward with the litigation. That means you're not going to have to engage in huge document production. You won't have to have depositions. You won't have to have all of the things that make US litigation so intimidating, costly, unpleasant for those who don't want to be in court and prefer to be in arbitration. So in the oral argument in the Supreme Court, the Chief Justice asked the counsel for the party seeking, the stay, well, why do you need it? You get your appeal. So, well, isn't that a very valuable right, an interlocutory appeal? And what the counsel said, and it was a winning argument, is if I don't get the stay, the appeal is divested of a lot of its benefit because I have to go forward with the litigation, spend a lot of money and time. And then what happens if the appellate court says your appeal is granted, you can go to arbitration? I've lost all of that time, all of that money litigating in the federal court. So that is one of the leading US Supreme Court cases in 2023. Now, what about the reverse of the situation? What if the motion to compel arbitration is granted? What happens then to the court case that was initially brought? Well, now we have an answer just a couple of weeks ago, just decided in May of 2024 in Smith versus Spitzieri, again, a Ninth Circuit Court of Appeals decision. This one is reversed 9-0. Do you know how hard it is to get United States Supreme Court justices? You know, there's a very significant divide, liberal and conservative. To get a 9-0 decision is pretty incredible these days. And it reverses the Ninth Circuit 9-0 because of the plain meaning of Section 3 of the U.S. Federal Arbitration Act. And I don't want to take time to put it up on the screen, but what it says is you get a stay if you get of the case that's in court if the motion to compel arbitration is granted. And the question is, does the district court have any discretion about staying the litigation or simply dismissing it? And here's the answer. The district court must stay the lawsuit while the arbitration proceeds. And why does it matter? It matters because you get to complete your entire arbitration, and the motion to compel arbitration cannot be appealed while the arbitration is going on. And why is that? Because you can't appeal because the case is stayed in the district court. It's not dismissed. If the case had been dismissed, you could have appealed the dismissal. But because it's been stayed, you can't appeal anything. So the arbitration goes forward. So you see in both of these Supreme Court cases, one with probably the leading case in 2023, Coinbase versus Bielski, and then the case that's just been decided this month, why the U.S. courts, including the U.S. Supreme Court, can be seen as very pro-arbitration. So in the first one, motion to compel arbitration denied, but you can get an immediate appeal, and while you're appealing, the litigation has to be stayed. Motion to compel arbitration is granted, the arbitration goes forward, and it can't be, the motion to grant arbitration cannot be appealed while the arbitration goes forward. So you see how significant is the support for arbitration. I want to, Ömer, if you go to the next slide, please. I want to go to, thank you very much, to one final major Supreme Court case in 2023. And I have to make a disclosure here. The party, one of the parties in this case is a former client of mine when I was at the Gibson Dunn Law Firm before I came to BonelliErede. And our client was Ashat Yegizarian, who was a Russian businessman and Russian politician who then left the Russian Federation and became a resident of California. He got involved in many lawsuits arising from his activities in the Russian Federation. And I'm happy to say, however, I can talk about this case with some freedom because amongst the many cases that Mr. Yegizarian was involved in and the many arbitrations, this one I was not involved in. And in any event, let me tell you why this is so important. So here's the background. Yegizarian and a man named Smagin, another Russian businessman, get involved in a dispute regarding a hotel project in Red Square in Moscow. Smagin brings an LCIA arbitration seated in London against Yegizarian, who at this point has become a resident of California. Smagin wins the arbitration and gets an award of $84 million against Yegizarian and seeks to enforce the award. Yegizarian does not pay voluntarily, seeks to enforce the award in the Central District of California. Yegizarian is told by the district court, you must pay. The award is enforced. And Smagin seeks to try to find assets of Yeşilırmak. Yeşilırmak, again, refuses to pay. He creates, according to the facts as presented in the Supreme Court case, he creates a number of shell companies, both offshore and in the United States, and colludes, according to the US Supreme Court, with other entities in order to avoid paying. So what does Smagin do? Well, Smagin brings a civil RICO claim against Yeşilırmak in the California courts. And what he does is he brings the RICO claim alleging acts designed to frustrate enforcement of an international arbitral award. And what is RICO? Well, RICO is a statute that Congress passed, and I apologize, there's a typo here. It should be corrupt. I missed a T. The Racketeer Influenced and Corrupt Organizations Act. Now, this is a very controversial statute. It was originally targeted against organized crime, and in particular, mafia organized crime in New Jersey and New York in the United States. But it came to be used by plaintiffs against many persons and entities who arguably have no connection to the mafia or organized crime as a way of getting them to pay, for example, lawsuits that they're avoiding, or getting them to pay other claims that they refuse to pay. And so Yeşilırmak argues that a civil RICO claim cannot be a mechanism used to enforce an international arbitral award. But the Supreme Court agrees with Smagin. And this time the Ninth Circuit is affirmed. It's a 6-3 decision. So again, you can see a fairly robust Supreme Court decision, not so divided. And what it says is collusion to avoid payment of a judgment based on an international award constitutes the domestic injury that's required under the RICO statute. In order for a plaintiff to prevail under RICO, it has to plead and prove a domestic injury. And remember, this award is issued in London. It's an LCIA award. And so what Yeşilırmak was saying is, how can an effort to enforce an international award constitute a domestic injury under the RICO statute? But here, he loses. And he loses because the Supreme Court determines that an international award that is turned into a U.S. court judgment. Remember, the award is enforced against Yeşilırmak under the New York Convention. So it becomes a judgment, a California court judgment, because the award is enforced in California. And collusion to avoid paying that domestic court judgment, the Supreme Court says, constitutes the domestic injury required under RICO. And previously, it was very hard to show domestic injury. Excuse me. So this is another example of the US Supreme Court favoring international arbitration. It provides now, through RICO, a new avenue to pursue enforcement of awards. You know, in other instances, you might get stuck But if you can bring a civil RICO claim, you can put enormous pressure on a respondent. So if you flip the slide, Ömer. One second. Sorry, I'm back with my throat. Those cases are part and parcel of my opening comment that in interpreting the Federal Arbitration Act, the U.S. courts wish to favor arbitration. And here's how it works again. So there are three major Circuit Court of Appeal rulings that I wanted to bring to your attention in 2023, this afternoon. And the first is something that happens, and Professor Yeşilırmak, Professor Kafali, I'm sure, speak about this in class. The first happens in the context of the doctrine of functus officio, whereby the arbitral tribunal or the sole arbitrator, after issuing the award, is thought to only be able to correct administrative or clerical errors or interpret something that's unclear. What happens in this Second Circuit case, and Second Circuit covers New York. So this one is New York City. Smarter Tools versus Chongqing Senchi Import and Export. What happened was the sole arbitrator issued an award without reasons or with very little reasoning. It was challenged on the basis that the parties were entitled to have reasons because of the arbitration agreement that they had. And here, it might have been thought that the district court would simply annul the award. It's an award that was unreasoned. Instead, the district court doesn't want to take the finding of the sole arbitrator and throw it in the trash. There was an arbitration, there was a hearing, and there's an unreasoned award. So what does it do? The district court, the Southern District of New York, and this goes up to appeal on the Second Circuit. The district court remands the arbitrator's award to the arbitrator to provide reasons instead of simply setting it aside. And the Second Circuit says that is acceptable. Remand of an unreasoned award does not violate the Federal Arbitration Act, which also, by the way, just provides for, after the award, correction of clerical correction of errors or interpretation of a passage that is unclear, or the functus officio doctrine. Now, why is this important? Because it shows that, again, the US courts are so pro-arbitration that even when you're faced with the situation of an unreasoned award, even, arguably contrary to the parties' arbitration agreement and contrary to the strict terms of the Federal Arbitration Act, the remand is determined to be acceptable under the FAA, the Federal Arbitration Act, and not to violate the functus officio doctrine. So that's one very important circuit court ruling. The next circuit court ruling is maybe less important, but still very revealing. So in this case, 11th Circuit covering, amongst other states, Florida, a very important seat now, Miami, especially for Latin American parties in the United States. Corporación AIC versus Hydroelectrica Santa Rita, 11th Circuit. there was the standing law in the 11th Circuit was that when a party seated, for example, arbitration seated in Miami, seeks to vacate or annul the award, the grounds for vacating the award were Article 5 of the New York Convention. However, that meant that the 11th Circuit was an outlier. All other U.S. Circuit Courts of Appeals said if the arbitration is seated in the United States, the Federal Arbitration Act provides the exclusive grounds for vacating an award. So this decision is important more to bring the 11th Circuit in harmony with the other circuit courts of appeal. So I spend no more time on that. Instead, come to a far more interesting decision internationally. Grupo Unidos por el Canal versus Autoridad del Canal de Panama, an arbitration concerning refurbishment of the Panama Canal that was seated in Miami. Again, 11th Circuit decision. And what happened was the losing party representing the Panama Canal construction company brings a challenge to the award based on Section 10 of the Federal Arbitration Act, which has a provision that the award shall be set aside if it is shown that there is evident partiality or corruption of the arbitrators. And this phrase, evident partiality or corruption of the arbitrators, has been repeatedly examined by the U.S. Circuit Courts and District Courts after a Supreme Court decision in 1965 called Commonwealth Codings, which is very famous because it concerned this provision of the Federal Arbitration Act, and it was a very complicated 4-4 Supreme Court decision, and different language is used by different justices to try to discuss the proper standard for assessing evident partiality or corruption. In this case, the challenger to the award, and this is of interest internationally, again, something that I'm sure you discussed with Professors Yeşilırmak and Kafali, that in this interesting case, the arbitrators failed to disclose that they were sitting with each other in other unrelated arbitrations. And what the challenger said was, well, being an arbitrator can be very lucrative. And if someone becomes a chair in one case and they're sitting with an arbitrator in another case, it means that they will try to get along in a way that is bound to create partiality one way or another. And so the fact that they didn't disclose it, which is the only fact that the challenger had, there was nothing else to show evident partiality or corruption, just they didn't disclose that they were sitting with each other in an unrelated arbitration or unrelated arbitrations. The 11th Circuit said that is speculative. It is not evident partiality or corruption. And this ruling has in fact going to stand because the U.S. Supreme Court denied certiorari about this ruling, Grupo Unidos. And the significance of that is that the U.S. Supreme Court does not want to get involved in a redo of the 1965 case Commonwealth Codings. So on more than 15 occasions, someone's tried to get after a circuit court ruling, the Supreme Court, to try to revisit what evident partiality means, and the U.S. Supreme Court simply won't do it. And this is the latest example. So I just have a couple of more slides that I want to take you to. If we go to the next one, Ömer, I just wanted to show you this because this is ongoing in the United States and in other jurisdictions, and that's the enforcement of intra-EU awards. So in the U.S. District Court for the District of Columbia, and what this involves, and I know that there are some potential experts on AAA and ComStroy on this webinar. So I'm not wading into AAA and ComStroy, just the results of those rulings in the European Court of Justice and on intra-EU awards. And here's the interesting part. In the District Court for the U.S. District Court for the District of Columbia, 2 judges have come to the opposite conclusion. In 9-Ren Holding versus Spain, Judge Chutkan said that Spain's alleged lack of capacity to consent to arbitration under the ECT as a result of ComStroy was an arbitrability issue rather than a jurisdictional issue, and the agreement to arbitrate exists under the Foreign Sovereign Immunities Act, award to be enforced. Spain loses under the Energy Charter Treaty and refuses to pay because of ACMEA and ComStroy. The claimant investor seeks to enforce in the United States, regardless of whether Spain can get the award annulled in Europe. And Judge Chutkan says, I don't care what the European Court of Justice says. That's an arbitrability issue, not a jurisdictional issue. And therefore, there was a valid agreement to arbitrate. It wasn't vitiated by ACMEA or ComStroy, award to be enforced. And then what happens at around the same time? Exactly the opposite. Judge Richard Leon in Blasquet versus Spain. Again, Spain, which always seems to, not always, but almost always seems to lose these cases. He says the European Court of Justice's decisions in ACMEA and ComStroy deprive Spain of the capacity to agree to arbitrate, and therefore there was no valid arbitration agreement, no jurisdiction existed, and he refuses to enforce the arbitral award against Spain. Both cases are now on appeal in the DC Circuit and have been argued already in the DC Circuit, and we'll have to wait and see how they come out. There's already been a very strong decision in federal court in New York along the lines of Judge Chutkan enforcing the award. I'm sure you've all seen in the last 2 or 3 weeks, there was a very strong decision from the Swiss court on upholding an award and declining under an intra-EU award and declining to recognize the challenge under ACMEA and ComStroy. It's unclear how the DC Circuit will come out, but it is, of course, interesting to see 2 district court judges in the same district, both sitting in the District of Columbia, coming to opposite conclusions. And so on my final slide, I just wanted to come back to the issue about the relationship between the courts and arbitration. And here is someone you may have seen in the news lately for something having nothing to do with arbitration, and that is the music entrepreneur, Sean Diddy Combs. And Sean Diddy Combs is not only a music entrepreneur, but for many years he made, and it's estimated, maybe $1 billion because of his relationship with Diageo, a liquor distributor or spirits distributor in North America. But they had a falling out in 2023, and Diddy, as he's known, filed a claim in last year, actually just about a year ago, in state court. New York Supreme Court is state court. And he says that he was losing money because his liquor brands were being typecasted by Diageo as black brands that should only be marketed to urban consumers. So Diddy said, basically, it's race discrimination by Diageo. Diageo says, and this comes back to the first cases I was taking you to, there's an arbitration clause and moves to compel arbitration. Diddy says, well, there's an arbitration clause, but there's also a clause in the contract that says injunctive relief is for the courts. And he is asking, he says, for forward-looking injunctive relief. That's a very expansive definition, I would say, of injunctive relief. Now, the case has settled in January 2024. Business ties completely severed. The brands are now solely owned by Diageo. But why is it interesting? Well, it's interesting because of the motion to compel arbitration, because of this conflict, an arbitration clause that had both, as well as a referral to arbitration, a carve-out for injunctive relief, which, as we all know, is pretty likely to lead to this type of jurisdictional challenge. And then it's interesting because what if the Diageo and Sean Diddy Combs arbitration agreement had included a provision on sexual harassment or sexual assault disputes? Now, as I mentioned from the outset, that couldn't go to arbitration because it would be a pre-dispute arbitration agreement concerning sexual harassment or sexual assault. Now, there was no such allegation, I must emphasize, in Sean Diddy Combs versus Diageo North America. That was all about a race discrimination claim. But I just mention it because, as we all have seen in the press, Sean Diddy Combs is now the subject of many, many sexual assault lawsuits, and including one that was just, I believe, filed last week. But the interesting point here, leaving aside that very horrible situation according to the allegations, is the arbitration clause, the motion to compel arbitration, the carve out for injunctive relief. And remember, under the Supreme Court, what if the motion to compel arbitration had been granted? Could Sean Diddy Combs, who wanted to be in court and get a jury, could he have appealed that motion to compel arbitration? The answer is no. Under Smith versus Spitzieri, the court action would be stayed, and Diddy could not have appealed that motion to that granting of the motion to compel arbitration. He would have had to have waited to the end of the arbitration because the court case would not have been dismissed. So I think I've taken more than my permitted time. Thank you for the extra, and I'm happy to answer any questions that might have arisen. Over to you, Professor Yeşilırmak, Professor Kafali.
Thank you very much, Larry. It's as always, it's always wonderful to listen you. Two issues that I wish to make a comment, actually. One is Grupo Unidos. As Professor Russell Weintraub would have said, it was pity that the Supreme Court denied the opportunity to deal with the meaning of evident partiality in light of the concept of transparency in international commercial arbitration. Second issue is about Achmea and Comstroy. It was one of the first questions that I needed to answer in my scholarly life. Can a state rely on its own law to deny arbitration agreement? in respect of Turkish concession agreements, and my answer was no. So just getting back to our subject, and now you are qualified in both in England, in the UK, and the US. So if you wish to go to arbitration, which one would you prefer? Federal arbitration in US or arbitration in the UK?
So that's a fascinating question. I would say I'd be comfortable in both. I would limit the US to New York. I'd be comfortable seated in New York in an international arbitration because I think the Southern District of New York and the Second Circuit are extremely reliable courts. And I think they're comparable to the English High Court and the Court of Appeal and the UK Supreme Court. I would say the UK court system in supporting the arbitral process is probably quicker. And so you get through the system more quickly. And I think there's probably well, I wouldn't say a more settled jurisprudence. It's just more settled in the sense that if you get a ruling from the Second Circuit, it could always, the issue about whether it goes up to the Supreme Court, and this one relates to your Grupo Unidas point, Professor Yeşilırmak. There's always the issue about how it relates to what other circuits have determined. And you don't have that problem in the UK. So things are quicker and more predictable in a way. But it would be hard for me to choose between the two because I think they're both excellent and they're relatively quick, UK being quicker. I would be less comfortable at other arbitral seats in the United States because I just wouldn't have the same level of confidence about the judges. Although I'm sure that that's probably a prejudicial viewpoint from someone who grew up in New York City, but I'd just be less comfortable. I would like to, you raise a really interesting point on transparency and the Grupo Unidas. I think my view and to make a full disclosure, I was involved in a case that the Second Circuit decided, and it was a summary dismissal, and then it was dismissed again by the Second Circuit sitting on bank in Andes and Occidental, in which the arbitrator was challenged, and I was involved in the challenge because I had sat with the arbitrator in an unrelated case. And there, I think the determination, it's a much different opinion from the Second Circuit. It's a summary dismissal, whereas the 11th Circuit in Grupo Unidas gives a full opinion, a 25-page opinion. But the interesting part of the cert petition in Grupo Unidas and the opposition to cert petition, I should say, and the opposition to cert petition in Andes versus Occidental, is that evident partiality means what it says. That is, you've got to show something. You just can't speculate on the basis of a non-disclosure, which is a transparency point, as you raise, and Professor Weintraub raises, and some of the amicus curiae raised in those cases. But you can't just speculate that the ruling on either side in Commonwealth codings was, it can't be speculation. And the different language used by the different circuit courts of appeal all still recognized that it's a factual investigation, so that it has to be shown factually that there's evident partiality. And it is meant to be, as both decisions in the circuit court said, a high standard. So I think the Supreme Court thinks that, one, in denying cert, that the circuit courts are doing a good enough job in evaluating the cases. Some cases, the challenge succeeds, in the Ninth Circuit in particular, in other circuits, and in many it doesn't. But I think what the Supreme Court is saying, those decisions really don't need to be reviewed because they are factually based, and we're not particularly interested in those factual determinations. As for your point about Acme and Comstroy, I would be surprised if Blasket survives in the DC circuit. I think it'll be 9-Ren that is upheld. And like the Southern District of New York now, I think the United States will very much affirm the Yeşilırmak position on Acmea and Comstroy. I simply don't see the United States refusing enforcement on the basis of the ECJ decisions in Comstroy and Acmea. I think it'll be very much what Judge Chutkan said in 9-Ren, that it's the decision that was taken by the ECT tribunal was a decision about arbitrability, not jurisdiction. It did not affect the arbitration agreement, and therefore there's no basis to examine the award under the Foreign Sovereign Immunities Act.
Thank you, Professor Shore. Maybe we could have one more question for a couple of minutes. Ömer, do you have any questions?
Yes, we have a couple of questions, but due to the time limits, I'll pose only maybe one of them. The first one, regarding the Federal and State Arbitration Acts, have there been any cases where related contracts are governed by state and federal laws, respectively? And if so, how have the U.S. courts resolved such issues?
Well, that's a great and complicated question, but the short answer is the courts, when there seems to be a parallel issue, and it's state law versus federal law, if there's a conflict, then under the preemption principle, it's the Federal Arbitration Act that prevails. The trickier issue is there is no federal common law of contracts. So state law provides the substantive law for for contracts, interpretation of contracts. So in a case that's under the Federal Arbitration Act, seated, let's say, in Oklahoma, and the contract properly under the Federal Arbitration Act, you have a party from London and a party from New Mexico, but they chose Tulsa, Oklahoma as their seat. It's under the Federal Arbitration Act, but the contract itself is governed by Oklahoma state law because there is no federal common law of contract. So you almost always would have a state law aspect to the case. But if we're talking about procedure and default provisions, about the Lex Arbitrii, that's going to be the Federal Arbitration Act that will prevail. And most of the time, you're not looking at the state act.
Great.
Thank you very much, Larry. We should remind our audience that they could directly contact with you at BonelliErede. They could find your email address from the website. We could also have your contact details attached to our websites. Thank you very much for listening. Thank you very much for this great presentation. And we are also thankful to the Turkish Arbitration Academy and Dr. Ömer Kafali for his